The purpose of our conference is how to become an arbitrator. I imagine that all of you here attend the conference because you are all eager to be appointed as an arbitrator. It being said, are you sure you really want it? Are you sure you are masochist enough to carry the burden of the arbitrator fate for one miserable salary? Are you sure you are ready to read endless submissions, to listen to endless witness testimonies, and to bear endless hearings? Are you ready to work hard on the drafting of awards and to have them annulled for nonsense reasons by judges who don't even take the time to read your awards? Well, if the response is still yes, then I guess that, as we say in French, there is always a first time. The question is how to generate this first time. The best way to handle this topic was to discuss it with a panel. Our panel includes an experienced and well-known arbitration user, Christine Guerrier, VP and General Counsel Dispute Resolution at Thales. Christine will share with us her expectation when she selects an arbitrator. We also have an experienced arbitrator, Charles Kaplan, partner at Auric in Paris. However, he will provide us with his views, not as arbitrator this time, but as president of the AFA Arbitration Committee, which appoints arbitrators in AFA cases. Finally, we will hear from Anne-Véronique Schlepfer, partner at White & Case in Geneva, and Olivier Capras, professor in law in Brussels, two very talented, experienced arbitrators. They will tell us how to meet the expectations of arbitration users and institutions and how they got their first appointment. Please feel free to ask questions anytime. So first, we will focus on users of arbitration and on arbitration institutions. Christine and Charles, this question will concern you. Have you often selected or appointed as arbitrators who did not have any previous experience as arbitrator? And why?
As a user, I would tell you that I would never appoint someone who has never been an arbitrator previously. It's when you are in-house counsel, you have to manage your organization, internal organization, and of course, each case is different. And you would, for a company, arbitration is not something usual. It's usual for me because I'm in charge of litigation, arbitration, and whatever is dispute. But it's not for a manager entering into an arbitration. It's a new world. Most of my company is present in aerospace, space, aeronautics, and security, and of course, most of our managers are engineers. They have no experience with arbitration, no experience with disputes, generally speaking, as a matter of going to a court, to any kind of judicial experience. So they are a bit afraid that when I told them that's the only way to deal with that dispute is to go to arbitration. We already started to negotiate, we mediated. It's no, the only way is arbitration. And so, and you have to explain them, arbitration, it's not like court. That means that you have to appoint an arbitrator. and the other side is going to appoint an arbitrator, and hopefully together they will appoint a chair of this panel. So that's mean that and the decision is final and binding. So that's mean that if you lose, you lose. It's final. So when you explain that to someone and you tell, okay, I have a great idea, I'm going to take someone who has no experience as an arbitrator, you will see that it raises question of my own ability to deliver a service when no one, with someone who has no experience at all. So it could be a very, I could be in a very hot seat if I propose that to my management. Say, okay, let's take this one, he has no experience, that's going to be great. So it's very unlikely that I will appoint someone who has no experience at all. No experience as an arbitrator, but maybe there are some cases where you can think about it.
Okay. Thank you. Hopefully, because otherwise it will be very difficult. I'm afraid it will be very difficult. Appointed.
Yes, but I was talking about a panel of 3 arbitrators, yeah, and a big case. Okay, and there are also less important case where we can consider something different.
Okay, and you, Charles, as a representative of an institution.
I note the question is, have you often selected or appointed arbitrators who did not have any?
The answer to that question is clearly no. But I think I'm going to expand on the question a bit, because I think the often is a word that is maybe it's de trop. Have you ever selected or appointed arbitrators who did not have any previous experience as arbitrator? The answer is yes. And I will say that with 2 caps, actually, just to give as much and be as positive as one should be and as realistic. As with my institutional cap on, we just very recently had a case which was fairly complex, but a fairly small amount at stake, and parties who could not afford to pay a high advance on costs. Because at AFA, it's one of the peculiarities of AFA, we have a very, very broad range of cases, from typical major complex business disputes of the kind Christine manages to some really fairly small matters that are actually sometimes referred to us by French courts. And that was one of those. And the matter was complex, but relatively low value. And so the committee and I selected someone who we thought, by virtue of her experience, where she was working, who she was working for, she's the assistant to a very well-known arbitrator and former law professor, and she sits as secretary, or she assists him as secretary of tribunals all the time. We thought this was perfect. Here was a person who had the technical background, skills, expertise, who had seen it being done by the very best, and who could handle this matter, which was difficult, and is difficult. It's not over yet. But for a relatively small economic value, and who would not mind being paid a relatively modest fee. That also comes into the equation. If you want to get started, you won't necessarily make very much money on your first case. And my other example I wanted to give you, just stepping out of my role for 1 second. As counsel, have I ever selected someone who didn't have any previous experience? Yes. I've done it at least once, knowingly. Maybe in the other cases I did it not knowingly. And in that case was many years ago, and the then young man, I hadn't sat before. Today he's a very well-established practitioner, both as counsel and sitting on major cases.
You appointed yourself?
And I appointed my twin brother. No, but the point was, I was making a judgment call, and the client was kind enough to follow me on that call, which was, this guy wants to do this well. He's ambitious. He, in a word, as we say slightly trivially, he's hungry. He's going to read his papers, and he's going to work in that tribunal and make sure that, you know, every point that's made is clearly understood and gets across. And on that basis, and of course, he's also he's within a specialist practice, you know, and so on and so forth. We're not talking about appointing someone who does municipal bonds here, you know, as a legal specialism. No, we're talking about people within the area. So those are two examples of, yes, I have. I would do it again. I will do it again if we have the opportunity at AFA and the right case comes up, and we'll talk about the criteria exactly of when it's appropriate to and not, and what people should do if they want to position themselves so as to get that first appointment. Please.
Yeah, you mentioned that in relation to the first case, you said that sometimes some matters are being referred by the French courts.
Yes.
Is that with a new wave of sending a lot of matters to mediation that the TG is following at the moment, or is that something else?
Yes, there's also another, that particular case was because there was an arbitration clause out there, but it wasn't very well drafted, and the parties and their counsel weren't very sophisticated, and the court actually said to them, would you like me to make a recommendation of a center, that, because we were not, it wasn't a properly drafted AFA clause. And the commercial court in question actually suggested to them that they might refer the matter to us, which they did, and we said, well, we will take it. You just have to confirm that you will accept the AFA rules, and off we go. I mean, that's how that happened. That happens to us every now and then, yeah.
Thank you. When I listened to you, among the pros and cons of appointing a new arbitrator, you mentioned the fact that you could guess that he would take the time to read the papers, to read the files. So, Christine, maybe it would be a good reason to choose a new arbitrator, because maybe you would be sure that the arbitrator you appoint will take the time to read all the documents and all the files.
The problem is the first time arbitrator, but the second time arbitrator I will no more worries. Because I know that someone who was talent is going to make sure that he has the reputation to take care of. And I know that he will look at the case, he will work quite much more hours and train arbitrator someone who has a lot of experience, who would just go through the papers because he knows that arguments are going to be the same or whatever, or don't have the time to do it. That someone who has very little experience has to build his reputation. And of course his reputation is going to be shown into his work. And I know, and from time to time I appoint someone who has very little experience in arbitration when the case is not too complex, the amount at stake is not that much, or when I know that I'm going to lose anyway. You know, sometimes you know that it's not going to, but it's a good way to introduce someone to arbitration when you know I know that he's going to work, and he's going to work and do his best to find the best solution.
New arbitrator should say, choose me when you know you will lose.
Not always, but everybody knows that there are cases what we don't see how we could win. So you don't have anything to lose in that case, and try to have someone new. Why not? It's given opportunity to a new arbitrator to improve his skills, to work hard, to build his reputation. And I think that is something to consider. And of course, you have to look at you know, it depends when you are defendant, claimant, or if you have a three-panel arbitrator or a sole arbitrator. It's really it depends on a lot of characteristics of your case. A new arbitrator for example, an ad hoc arbitration, it's very difficult to make that decision.
Do you have ad hoc arbitration?
Very little,
okay.
But from time to time we do have ad hoc arbitration. And I don't see how I could appoint someone who has no experience as an arbitrator in an ad hoc arbitration. So it's obviously something that I would not consider. But you know, for a small arbitration, a sole arbitrator, why not?
So if users may have sometimes some reluctance to appoint new arbitrators, Charles, do you think that arbitration institutions have a specific role in that respect?
Well,
responsibility somehow.
Yes. You know, I know the period we live in when everybody is trying to do everything in order to cure all the ills in society. It's a tendency in general I'm a little bit skeptical of. You know, the business of business is business. The role of an arbitral institution is to administer arbitrations in such a way that the users of arbitration are best served. And that means that they have a process that is properly run by competent people, that good decision makers are appointed. And if we want to look a little bit beyond that, yes, as an institution, we have an inbuilt interest in arbitration itself. And having an interest in arbitration itself means having a pool of arbitrators from whom we can draw, not just today, but tomorrow and the day after tomorrow, and so on and so forth. So being purely pragmatic about it, we have an interest in having arbitrators, old, medium, and young, with a varied set of skills and competencies and backgrounds, because that's what our cases look like, and that's what our parties look like. So to that extent, yes, but if you're looking to the AFA as a militant organization to promote the cause of this or the cause of that, yes, we do. We promote the cause of arbitration.
And so would you limit the new arbitrators to the young arbitrators?
That's a very good point. That's a very good point. Widening the pool means potentially selecting people, including people who maybe come to the activity relatively late, because, well, I mean, some of our most well-known and active arbitrators at the moment, at AFA and elsewhere, are people who had previous careers doing something else. Some of them were working in industry. Some of them were lawyers, but they were doing M&A transactions, for instance. You know, and so absolutely, that's a vitally important point. We mustn't lose sight of. New doesn't necessarily mean young.
And Christine, when I listen to you, I guess that you will probably say that the appointment of a new arbitrator will certainly depend on whether he will be a sole arbitrator, co-arbitrator, president. I think, of course, it's a criterion for.
Yes, it's first of all, I have very few ad hoc arbitration, but as I said, I don't see how you could appoint someone who has no experience previously in arbitration to be sharing a panel of arbitrators, and secondly, you know, the problem is, and you have to have a panel of arbitrators which is well balanced. Otherwise, you might have so difference. The difference between arbitrators. It's I'm not an arbitrator. I've never been an arbitrator. I don't intend to be an arbitrator. But from what I see is that you have to have some chemistry between this panel so they can work together. So if you appoint someone who has no experience at all in a three-panel arbitrator, where the two other arbitrators are going to be very senior arbitrators who have done that for 20 years, it might be a little bit difficult for this arbitrator to have a real role into that panel, and try to present the best argument for the case during the negotiation, or not negotiation, but deliberation between. So it seems to me it's easier to appoint a new arbitrator as a sole arbitrator, because it doesn't have to take care of that balance between the panel. Of course, if he's in a three-panel arbitrator, he would learn from the others. That's a good experience too. But it may be, when you are the claimant, you have less control over the appointment of the two other arbitrators. Of course, your choice will condition the choice of the other side and then the chairman. So, but as a defendant, you already know who has been appointed as arbitrator by the other side. So you might be able to adapt a little bit your choice. And maybe if the other side has appointed someone who is rather new, why don't you can take that opportunity to have someone who has the same level of expertise, and have a chairman who has more expertise. In that sense, that would be a way to distribute. But of course, it's a lot of consideration that we are talking with our outside counsel with. It's not my only choice. It's a choice that which I would share with my counsel, and will take into consideration all the advantage, disadvantage of each position.
What you said about choosing a new arbitrator in the case of a sole arbitrator, I'm not sure I would have made this response as far as I'm concerned. And in France we have this concept of petit juge. We know we had very bad experiences in some criminal affair about the so-called petit juge, which means young judges who were appointed as investigating magistrates in very high-profile criminal cases, and it was just a nightmare. And so if we compare the situation with the one of arbitration, I don't know, what do you think about it, Charles?
Well, I think that's a very good question.
There are two possibilities. And of late at AFA, what we've tended to do when we've had the opportunity is that some of our smaller cases, which in any case only warrant the appointment of a sole arbitrator, we have, because we thought we found capable newcomers. So we were confident to appoint as sole arbitrator someone who with no previous experience, given that person's background. But another configuration which is also interesting, and which might also be an opportunity to give someone slightly more ambitious first appointment, now again, that person would have to be experienced in some sense, maybe not as arbitrator, but as counsel, as tribunal secretary or whatever. And a configuration that can work is to have the less experienced or even the first time arbitrator in effect presiding over a tribunal with two experienced co-arbitrators. That can work very well. The case may be of such a size or relative complexity that the senior arbitrators might not otherwise handle it. A good rational economic way to manage it is to have the younger person, in effect, as president, doing most of the spade work, doing most of the hard work on the award and all the rest of it, and in effect, relying on two more senior arbitrators to give their opinion, obviously, to participate in the decision, but essentially to advise and encourage. And that's, I've been in that situation myself, although it wasn't my first appointment, but I've been in the situation where, in a largish case, I had on both sides very senior arbitrators who basically, didn't want to do the work on that case, and were very happy to, let the young guy. That was a few years ago. Let the young guy do the hard work, and we'll just tell him what we think. That's actually a good learning configuration. Works quite well, and is something that should be encouraged, in my view.
And would your choice depend on whether the arbitration is domestic or international? Do you think it may be a good way for a young arbitrator to concentrate on domestic arbitrations rather than international? Because we would consider that, by essence, international arbitration may be more complex than domestic, which, frankly, is not the case. But what do you?
No, I mean, that's a good question, particularly for AFA, because AFA, of course, does both. We have both international cases and domestic French cases. I don't really think it's a big criteria for discriminating between, less and more experienced, less and more complex, to be honest. In fact, in practice, if we're looking at less experienced candidates for appointment, they will probably have had exposure to both forms of arbitration in any case. So, in practice, no, I don't think that's a very significant filter.
And do you think it's absolutely, it's important, it's necessary to have been secretary to arbitral tribunal before being appointed? What do you think of?
I was going to say, I think there are really sort of three ways in to your first appointment as arbitrator. The one is counsel in a number of cases, and so obviously maybe the first time somebody, maybe you're an associate in an arbitration department. The second way in is as it were associate, because we now have little arbitrator boutiques with associates. What do associates in arbitrator boutiques do? Very well, a lot of the time they're secretaries to tribunals. Yes, the temptation from an institutional point of view would be to say, that's even better. I don't want to say that in any categorical way, but you can see that from an institutional point of view, we might say, oh, that really is our comfort zone, because we're not appointing Professor so-and-so, but we're appointing Professor so-and-so's assistant, which is almost as good. I wouldn't want to say, that that's better than anything else, but it is obviously relevant. Having done that, that's clearly relevant. And the third way in is the person has been in industry, has been a user of arbitration, has followed it. Now that has to be someone we really have to be persuaded who really has spent a fair number of waking hours thinking about it, following it, but an experienced user of arbitration's first appointment as a co-arbitrator seems quite natural. So those are at least three ways in I can think of. There are doubtless others. Maybe you, in the audience, you'd think of, how about this as relevant experience? There probably are. And I was going to say a fourth way in, which we don't think of that much, very popular, for instance, in England, is retired judges. In some cases, yes, why not? As a category, am I crazy in favor of retired judges? Maybe not so much.
Okay, yeah, sorry. Alors, to the attention of the viewers, please remind that you can ask questions via the chat. So don't hesitate, because so far we did not have any. I'm looking very regularly on that item, but no questions came so far. So don't hesitate, please. Christine, so what would you have as advice for anyone who would like to become arbitrator, for whom it is really the purpose of life, you know. So
first, there are a lot of people who want to be arbitrator, and that's there is a lot of young and not so young people who are interested to be arbitrator. But it's I don't think that's a easy path, and obviously you know, for example, young generation, usually it's a team at boutique arbitration or bigger law firm who have a long practice of arbitration. That's probably the best way to be a counsel, and then because you have been working quite hard, and user have noticed you during that work, that during the usually as in-house we work quite closely with the all the counsel on the team of arbitration, and you know who is really bringing his expertise, his abilities into the general teamwork. And there is also a question of personality, because an arbitrator should have the ability to make decisions, and not look always to the partner who is going to make decisions. So you have to prove that you are able to take decision at a difficult avenue on your case. And so it's not that everyone is able to be an arbitrator, because it's not, you know, the glamour of arbitration. It's not that it may be a little bit superficial, but it's a lot of hard work. And artwork, not only because you have to read a lot of paper and go through a lot of arguments, but at the end of the day, you are making a decision, and that decision could have a large impact on the parties involved into the arbitration. It's binding arbitration. So that means if you make a decision and the decision is wrong, you will have to bear the burden of that decision. So it's better to have that notion that it's not because you are going to travel the world and as an arbitrator, it's because you have a responsibility. And today you have some accountability as well, because you see that there are parties who go after the arbitrators. So it's quite important to realize that at the end of the day, your decision is going to have an impact on the parties. And that's a huge responsibility that you are taking. So it's hard work, but it's a lot of responsibility as well. And I think that not everyone is ready to take that responsibility.
I think the audience is now all frightened, and they will never want anymore to become arbitrator. But Charles, would you have, besides all what you have already said, but would you have one or two pieces of advice to give to the audience to become arbitrator before we turn to the arbitrators as such?
Sure. Well, again, I think that in most cases, particularly the younger, if we are talking about the younger new arbitrators, it supposes that you are already positioned professionally in a specialism that's relevant to what we do. So you're working in a firm as an associate, you're working for an arbitrator or arbitrators as a tribunal secretary, as an assistant. I think we have to be realistic. As far as the younger new arbitrators are concerned, we're not really going to have much opportunity to look very far outside those circles for, you know, new blood. I mean, that's where it's going to come from. And obviously, I would be open to any suggestion anybody makes to me if I'm looking for an arbitrator about, you know, have you thought about so-and-so? And if the case is made out that so-and-so is particularly qualified, then why not? But in 99 cases out of 100, the person will be from that background. Now, there, as I said, there are other situations where people come to these things relatively later in their careers, and that, of course, involves making an active move. You have to go out there and say, hey, my interest, you know, talk to all the appointers, be it the institutions, be it the users, be it the council, and say, well, you may not have thought of me before now, but I think I have interesting experience. And you've got, I mean, it's marketing, I'm afraid. This is a market, and if you are not known to the market, then there is no chance the market will recognize you and pick you. So you're going to have to go out there and toot your horn, because nobody else is going to do it for you, I'm afraid. So sorry for rather pedestrian advice, but there it is.
We did not speak about, because I see some of them here in the audience, of experts who want to become arbitrator. For them, would you, I mean, what do you think, and how should they become arbitrator if they want to?
Well, they have an advantage, of course, which is that they know the market. So, but they're going to have to do the same thing as everybody else. They're going to have to say, up until now, you've only thought of me as an expert. You know, would you think of me? And I suspect what they probably need to do is to give themselves some kind of scientific and intellectual legitimacy, because they'll have that in their specialism as expert. So they're going to have to acquire it in a more adjudicatory function, and they're probably, and this is true of everybody, by the way. Publishing helps. Publishing helps. That's absolutely, you know, if you're known to have published something, now it helps, and later on it hinders also, because when parties start getting picky about what your opinions are on this or that question, it hinders. But at the beginning, it helps.
Thank you. I think that there is one question from the viewers that I will ask to our arbitrators. So thank you for the question, but I will ask it later. So now let's focus on the arbitrators. I did not forget you. I saw that you were getting very worried, but no, I did not forget you. So yes, the question, the very hot question is to know how both of you became for the first time arbitrator, if you remind of this very first time. What is how did you get your first appointment as arbitrator? Sorry. And your turn.
I'm so young now. I remember it. No, apparently that's a good question. No, I don't recall exactly. And when was the first appointment? And the reason why is it's not just Alzheimer's starting early. It's a fact that, at least in my case, but I guess it's the case for many people, you don't get, one day you come to your office and you get a very nice appointment, and you are appointed as an arbitrator, nice parties, nice co-arbitrator, you render an award and everybody congratulates you, and so you remember it very well for the rest of your life. The reality is much more blurred than that. Why? Because at first your names circulate, which means that you get proposal, or you meet, I don't know, an in-house counsel or a colleague at a cocktail, say, oh, I was thinking of you as a potential arbitrator in that case. You say, yes, of course, I would love to, but there's no follow-up. So there is a kind of gray zone where your name becomes to be a part of the names which are considered for appointment, but you're not there yet. So, but if I have to really mention one specific case, I guess the first one, and it's probably interesting for you to know, came the following way. I was asked by a company, an American company, which is active in Europe, to make a kind of note at a certain point about how a clause limiting liability would apply in my jurisdiction, which is Switzerland. which is the normal advice which we may all get. And apparently they were happy with the product I gave them. And they then organized a kind of sort of webinar or something like that for their group to discuss this. These very general rules and principles which apply. And following that, a few months or maybe 6 months or a year later, the in-house counsel asked me, by the way, would you accept if we were to appoint you once as an arbitrator? I responded, yes, I would love to, although, to be frank, I would prefer if you were to appoint me as counsel, but I would, of course, be happy to serve as an arbitrator. And
why would you prefer to be appointed? Is it more
no, for lots of reasons. Maybe I will respond to your question afterward. First, because when you're young, and we'll come to that when we come to the question of the profile, I think you'd better get a very good experience as counsel to profile yourself as an arbitrator. I mean, to me, it's an important step. So, but I got the first appointment, which I could not accept at the end. Why? Because there was a conflict of interest. But that was the first, and it's quite interesting because you see, what makes you known by someone who is ready then to appoint you is because you've shown your experience or your competence in a certain manner. And then I think when you're young, the best way to get appointed very often is by institutions. Why? Institutions know better which cases can be given to someone who is new. And at the same time, it's sometimes less risky than for a counsel. Although I must say as counsel, I do think very often, depending on the cases, and having new blood, to be totally frank, and again I will tell you why a bit later. But appointment by institution, ICC, LCIA, very often as chair of a tribunal rather than sole arbitrator, this is a good way to get started. So try to be known if you want to be appointed at the beginning, maybe not the first, but the second, the third, or whatever. You have to make sure your name is known by the institutions which have the sufficient number of cases to be able to have a case which would suit you.
Thank you, and Véronique, so your turn.
My turn, okay,
Olivier.
thank you. In fact, I can precisely tell you when it occurred. I do remember it perfectly. I do remember the call. And it was thanks to an institution. Just to follow up on Charles and Véronique. It was almost 20 years ago. At that time, I was a research assistant at the university, and I was a member of the bar, too. And I had written some papers, and I was invited to present a paper in a seminar organized by an institution. And the week after, the chair of that institution gave me a call, inviting me to sit as a solo arbitrator, which is important because we always say, well, as a young arbitrator, you will learn thanks to your co-arbitrators and so on, but in many cases, the first case you receive, in my experience, when I look at newcomers and so on, are cases where a solo arbitrator is appointed. It was not, of course, a high-profile arbitration, but it was thanks to that, I think, presentation and the discussion that followed that the chair called me and, of course, looked carefully after the work I did. Apparently, they were not completely dissatisfied, and but that was the first one 20 years ago.
Thank you. So maybe you said it, but sorry if I forgot. But how many years of experience as counsel did you have before being appointed? Do you remember that, and Véronique, or?
Yes, because the first case I was involved in as an associate as counsel. So of course not at least counsel, but as an associate, I was 26. So it took, well, 10 years to have an appointment. But then two factors matter here. At 26, you just don't even dream of being appointed as an arbitrator. So it takes time also because I started pretty young to be involved in that field. but also I think a certain time of experience matters when you get appointed.
I do agree that experience as counsel is very important. I do think that also for arbitrators, experienced arbitrators. I'm not against the double hat. I think it's good for arbitrator to still remember how it works for practitioners, for counsels. Otherwise, you are facing people saying, okay, well, for next week, you're going to do that, right? Okay, everybody is okay? And then someone is raising, I beg your pardon, Mr. Chair, but do you know that it might be difficult? Why? Why? If you're still a counsel, you do know why it might be difficult to reach your clients. Well, that's a parenthesis. I think that at the time I had around 5 years experience as counsel.
So you were both pretty young, finally, when you were appointed as.
Yes.
Yeah, good. It happens. It happens. Yeah, had you been appointed as a secretary before getting your first appointment as an arbitrator, Anne-Véronique?
Yes, I did, because the law firm were two arbitration specialists sitting essentially as arbitrator, not say always as arbitrator, were active. So it's true that I did learn a lot by serving also as secretary of the tribunal. I did not do that too often. And unless you're really in an arbitrator's boutique, as was mentioned before, I think it's very good for you to serve as a secretary for two reasons. First, because it really shows you the job of the arbitrator, because even if you don't do it yourself, you are pretty close to the ones doing it. And that is very, very good for your own background. And it's also useful for you when you, by the way, when you work as counsel, because you then better see how the production of counsel is received by arbitrators, and you realize that a letter of 5 pages asking for nothing is just a nuisance. So you might not do this again, or not that often, if you have been sitting on the other side of the table. So, but I would not do it too much. Why? Because if you really have the tag Secretary of Tribunal, the risk is that it really remains carved in stone for quite a long time. So beware to diversify what you can offer.
Thank you, Anne-Véronique. Olivier?
On the same question?
Yeah, on the same question. Sorry, had you been... No, we will come to the profile after, because in fact there are several questions which do concern directly this raising the profile. So,
okay.
No, just
because
being a secretary.
Yeah, in my way it was just the other way around. In the first case, I've never been appointed as a secretary. In fact, I have officially been appointed secretary only one time in my life. And I do agree with Anne-Véronique that you must be careful of the image you are sending to the community. And there are many ways to give the image you want to give, which might be being a kind of professional secretary. That's something new on the market, and that might be interesting. There are floating secretary, independent secretary, appearing. But if it's not the position you want to be in, there are things to do. But I know, for having prepared that with our wonderful president, that
because you used to work. Well. A very prestigious boutique of arbitrators, but yeah, what you say is that you were not as
the fact is that I got started in a law firm which was not specialized in international arbitration, and at the same time doing my PhD at the university, and it's only after an LLM in the States. By the way, this is going abroad, of course, is in my view something absolutely necessary if you want to raise your profile. And it's when I came back, then I joined a boutique law firm known for arbitration. And there you're right, the work I did was only devoted to arbitration, only working for arbitration as counsel, helping the big names in their counsel work or in their arbitration work. But even there, officially, only one secretary position. And I was happy with that because of what we just said.
Thank you, Olivier. Maybe we, because there is a question of a viewer and I don't want to forget it, so maybe we will come back to Charles. Charles, there is a question of a viewer which is the following. Will you, as appointing authority at AFA, consider appointing someone inexperienced as an arbitrator because he or she has a very specific expertise, they know a specific language, for instance, or do you absolutely need someone specialized in arbitration?
Well, so the question is someone who not only does not have experience as an arbitrator, but who doesn't actually have any specialist competence in arbitration.
But he has
That's
specific expertise in
yeah, well, that's difficult. I don't see a configuration in which that could work. Bearing in mind that the institution most of the time is going to be appointing sole arbitrators or presidents of tribunals. So the idea of a sole arbitrator or a president of a tribunal who has neither experience as an arbitrator nor particular knowledge of how arbitration works, bit of a long shot for me, a bit of a stretch.
So now, yes, let's talk about the profile and the way to raise the profile. And I think the question will correspond to some question of the viewers. So, Anne-Véronique, how would you do to raise the profile of the audience, generally speaking?
I think we can take, if you don't mind, I think all the questions on profile, I think really good together, so they would be good to deal with them together.
Yeah.
I think the first thing is it's for us good to know that one has to raise one's profile. This is not always obvious, maybe obvious for you, but for associates working in very large law firms, they sometimes completely forget that they have to do something more than just being an associate in a law firm if they want to be appointed and want to be known at some point by the market. So raising the profile is at the starting point. How do you raise your profile? There are various ways, and you have to adapt to your own competence, to where you are, to your own specific background, and to the material, the possibilities, the opportunities that are around you. I don't think there is a magic rule that would apply to everybody. The thing is, at least for the younger people, you have to be one of the few which are selected, which appear on top of the category in which you're in. And how can you do that? I think the first thing I think you have to do is to listen. That may be totally stupid, but let's try to understand what people having experience say. Build your own opinion when you go to a seminar, when you go to a conference. Don't try to be the one who speaks, because even if you are extremely clever, if you have no experience whatsoever, what you may say may be either beside the point, stupid, or of such a platitude that will just disserve you. The first thing to raise your profile, just listen, see what are the issues, read the case law, try to improve your own knowledge before you try to give your opinion on something. And then also, when you want to raise your profile and start being active, it's easier if you're young to do it in younger groups than maybe in a very select arbitrator seminar. It's not that you don't have to do it, but it's easier if you are among your peers to speak and to discuss and to express your views rather than in other fora. Publishing is, of course, a good thing. But when you publish, you have to think about what you're publishing, whether what you're publishing is of interest. when I receive draft articles by associates, sometimes, I'm sorry to say so, but sometimes you really want to cry. I mean, it's just de tout temps, tous les hommes, you know, for those who speak French, that kind of thing. That doesn't have, don't do that. Don't do that, because the image you're going to project is, okay, well, better not. So try to find a topic, try to first have something to say before you publish. Then when you publish, be very careful to publish something that is not going to go against you in the future. So you can express your view on something, but at the same time, I recall once, maybe I can give you that example, someone who was really, really happy to write about confidentiality in international arbitration and try to make a kind of parallelism between investment arbitration, commercial arbitration, and gay marriage, saying that's a question of evolution of society. No, I promise. I'm not sure it was a good starting point for an audience that is specialized in international arbitration.
So maybe interesting.
Of course, but think to who the public is going to be.
Gay marriages which are being arbitrated, or what was the point?
The point was that the old guard did not accept gay marriage. The young guard were favorable. The old guard in international arbitration did not like the idea of not having confidentiality. The young ones knew that confidentiality was about to disappear. So that was the general starting point. So that's an example. And the reason why I'm giving this to you, it may be interesting in a discussion among friends, among peers, but if you publish something like that, it's not the best way to enhance your profile. So the point is, when you try to enhance your profile, make sure you do it in a clever way. And one way that is not too stupid to do it is have it checked by someone who has more experience. When you draft something, an article, or when you prepare a conference, a small speech, or an intervention in a conference, have it checked by someone who's more experienced. If you are in an area or in a field, you will find people helping you and advising you. So that's always good. Don't try to be very clever from the starting point. To be involved in professional associations, yes, because again, arbitration is a question of profile and of human contact. So you need to be known, you need to be accepted. So associations, arbitration associations are places where you will meet people who potentially can, either recommend you or directly appoint you. Again, try to position yourself in a manner that makes you seen. You are seen among the group. If you go to a conference with 500 people, it's not always easy to be the ones people will remember, but try to do something to be seen, and maybe start by younger association. For instance, personally, one thing which I did, which really projected me a lot in the front of the arbitration world, was to create the association as I below 40, and then YAP. So that was fun. That was extremely interesting from an intellectual point of view, but also that puts you on the forefront of your generation.
Thank you. Olivier,
same question. Okay. I'll try not to repeat all the sound consideration from my friend Anne-Véronique, but I will. Sorry?
I'm sure you have a lot of others.
Thank you. You are so kind. But I will try then, with your permission, and in fact, even without, no, I'm kidding, of course, Mr. Chair. Being funny, for instance, is not to put in the forefront of the way to raise your profile. No, I'm kidding. I'm just thinking the other way around. I'm thinking that having some sympathy, the capability of welcoming people, being tough, capable of being tough, but at the same time, welcoming people who have chosen you, who are paying you, who are expecting you to work a lot. If you can do that by having an as pleasant moment as it can be when people are fighting, is it also part of the qualities you should try to develop, at least in my view. But in order to maybe have another way of dealing with things, with your permission, maybe I will touch upon what I know as will be your last question, advice to give. And because raising your profile has to do with giving advice. My first advice is, please do think about what you really like in life. There are a lot of people dreaming about arbitration. And I see that at the universities where I'm teaching arbitration and corporate law. All the students are dreaming of arbitration. And I seeing that as a word, I think the word glamorous has been, it's true. It's not always glamorous to be alone in your hotel at the other side of the world when your baby is in another country. It's a lot of work. It's reading paper. And it's a place where young people, and I don't refer to age, I refer to the capacity of working, the fighting spirit, but also of age, have something to raise their profile is to work hard, even hard to death on small cases, because the first cases you're going to receive will not be that interesting in terms of money. Less interesting than the cases you're given by the firm you're working as an associate, so that you will have maybe a tendency not to devote the time necessary to the first arbitration because it's small potatoes in the firms you're in. That's the other way around. You do that night, if you understood me. So in terms of raising the profile, think about what you do like in life. For instance, in my case, I also liked doing research. That's a big word in law, of course, research. And that's the reason why I wanted to get a position at the university, why I did the PhD. And that's one of the rare private practice sector where being a professor is regarded as not the quality, but one of the possible qualities. In the past, it was almost one of the essential qualities. It's not anymore. I don't say that it's not good to appoint someone who is only a professor, but being a professor is raising your profile because it shows that a scientific committee has recognized your merit. You have published, and so on and so on. Publishing, of course, publishing. But then it's true, and Charles was perfectly right, as always. It's recorded, so maybe one time he will plead before me, and I will say, okay, he's right, and I will be challenged, so I withdraw. But you publish, it's good publishing, but you will find one day someone saying, as one of the distinguished members of this panel wrote some years ago, we do consider that, and they're quoting you. And that's an opinion that you have to take into account. So publish, but there are reviews, there are legal journals not to publish in. For instance, I would not accept to pay to publish, never. I don't say that that's bad. I give my own policy. I do not pay to be published. Publish on what is interesting, not repeating what others have said, and so on and so on. Try to be a speaker in conferences. But in order to be invited as a speaker, you need to have someone who spotted you for some reasons. And these reasons are quite difficult to identify, but it's being present in the community, in the seminars, in so on, publishing, and so on. And for my part, what was of crucial importance before I launched my own law firm because of conflict of interest, as Anthony referred to for our very first case, which is really so sad, conflict of interest. Before doing that and going solo, going into a boutique law firm or in a huge law firm, but known as very specialized in arbitration, is of tremendous, for me, is of crucial importance. People when I was younger, my 18-year-old daughter would say, you mean 20 years ago or 30 years ago? Let us say younger. I remember that all over the world, when I said where I was working, people knew immediately that I was working with Top Guns. And so that gave me some credit. And more than that, I learned from them. I worked for them, but I was also able to ask questions night and day, really, for my own cases. Well, can I accept this case, or is it a conflict of interest? And you learn a lot. You listen and you learn. So going to this kind of law firm is very important. Association, Anne-Veronique spoke about two beautiful below 40. I remember taking the Thalys with one of my friends to see Philippe Pinsol, someone Anne-Veronique knows a bit, I think. And he was then the chair of the YAP, I think, with you. Yes. But with Louis Degault. With Louis Degault. And we said, okay, we are two Belgian guys. And we would like to create, and we created, the Belgian Below 40 Association. It was a long time ago, and we would like to join the YAP. Would you be happy with that? And they said, that's fantastic, and that's the first time we met, and that's the way we get to, I think we place our name on the map. Because then we were invited to present the Belgian Below 40 during a Below 40 ASA conference in Geneva, and we went there, and so on. And I will finish. I will terminate with the advice, in fact, to make the link with what is supposed to be the last question here. I've thought about that first. Who am I to give advice? Olivier Capras. In Paris. Where am I? So please, it's with some true modesty that I would give you some pieces of advice. Devoted to two different arenas. The first one is outside an arbitration procedure. The advice is how to get your first appointment and how to get your second appointment, because that's the most important thing. It's not the first one, it's repeating the process, of course. The first arena is outside an arbitral procedure, and the second is within the arbitration procedure. And I promise, and that's not a lawyer promise, that's a promise, a Belgian one. So. Outside an arbitration procedure, if you want to increase your chances, my motto would be present, like you are here. We're going to meet, we're going to discuss, exchange business cards. We sympathize through some questions. I say, wow, that's a very smart girl, lady, and I will not forget a name. In this sector and so on. Be present, but please, not being too pushy, and for my concern, never ask for an appointment. Never ask for an appointment. Please, you know that I would like to be an arbitrator, and here is my business card. Would you like thinking of me? I think that's really not a good thing to do. Being present, but not pushy. That's for the outside arena. What about the inside arena, which is much more important? The very first time you're involved in arbitration, not as a solo arbitrator, but, and Christine referred to that. What do a very young arbitrator with older arbitrator, older professor and so on? That's very important. And there you can make a name. There you can make a name, and you can help your name circulate. My advice would be, don't be afraid of your shadow. Don't be afraid of your shadow. If you want to be an arbitrator, even solo, you have to be able to take decisions. And there are people behind that. There are companies and so on. And law is not black or white. It can be gray, so it's difficult. Don't be afraid to take decision. And don't be afraid of your shadow. Anticipate. Work very hard, even if it's a small case. And these would be my final words on this. If you do think during the hearing, during the discussion with the co-arbitrators, that you are treated like the young one, do something in order for the other to understand that you may be young, but you have to be respected. And there are many ways to do that, but these are my these are personal knowledge that I will only share for a lot of money. I'm kidding, but that's very, very important. Just to tell you, that's an anecdote I've already told in different arena. I remember a case where the two other arbitrators were at the age of at least my father, and one of them kept calling me, and what does the young Olivier think about that? This was not a way of being kind with me. This was not at all a way of being kind. This was a way of taking power. He was a co-arbitrator. And I said, okay, dear, and I will not say the first name, is a famous one. And we got friends. We got friends afterwards, and I think that I got his respect. I said, okay, well, the next time you call me the young Olivier, I call you the old X. Is it all right? You get my point? Look at me like that, but I really was not okay. I think we perfectly understood each other, and that's it. And I know that this is something that helped me, since he told that anecdote to someone who repeated it to me. But I have been too long.
Thank you very much for your time. Thank you for your advice. Oh, sorry, yeah, very quick, because I think.
Arbitration magazines do you think are up there in terms of publishing your content, please?
Which what?
Arbitration magazines are up there in terms of publishing your content for someone
There is ASA Bulletin. There is the ASA Bulletin is an important one. Arbitration International, Journal of International Arbitration, La Revue Française d'Arbitrage. For me, and it's not because I'm here, but sincerely, in French, that's the best in the world. La Revue Française d'Arbitrage. La Revue de l'Arbitrage. Pardon, Revue de l'Arbitrage, pas Revue Française. Revue de l'Arbitrage. Les cahiers. The bulletin, the ICC bulletin, to name a few. And B Arbitra, that's the new Belgian legal journal. Now we are on the Kluwer website or blog.
So thank you very much for your time, for having shared your experience with the audience. And before we all sit together in arbitral tribunals, I invite you for lunch. Thank you very much. And thank you.